All right, hello everyone. This is Corey Talbot. I am a partner at Holland and Hart, where I work in the firm's commercial litigation group, and part of my practice is antitrust litigation and counseling. And we're here today to talk about antitrust and healthcare. We've got a few slides, a couple things before we get started. If you do have questions that come up during the presentation, please feel free to send them in by the chat function, and probably what we'll end up doing is responding to those by email after the presentation. If we do have time and there are questions that we can work through quickly, maybe we can fit those in, but generally we'll just address those by email after the presentation. So with that, we'll go ahead and get started. First, kind of the basics about what we're going to be going over today. This really is going to be a basic introduction to antitrust enforcement, and specifically how that works in the healthcare arena. There are not a lot of bright lines in antitrust enforcement, and so there are some pitfalls, but they're pitfalls that often can be avoided, and we can stay safe by having an understanding of what agencies are concerned about, what competitors are concerned about in the antitrust arena. All right. So first, who's looking at these issues? And the big one here is the Federal Trade Commission, the FTC. They have a group specifically that addresses healthcare issues. And on this, the FTC has, in the last decade or so, become much more aggressive in antitrust enforcement. For example, the FTC's earlier sort of unwritten policy was that if they were challenging a merger, let's say a hospital merger, they would typically file an administrative action and at the same time ask a federal court to enjoin that merger while the administrative case was pending. And if the federal court denied that request and refused to enjoin the merger, the FTC would very often just say, okay, well, it seems like there's not a lot of merit to what we have to say. We're going to back off and not proceed with the administrative action. That attitude has changed, and beginning in kind of the mid part of this, the first decade of the 2000s, the FTC announced in one case that it wasn't going to follow that anymore. Now, that's not to say it's always the case, but it does show that the FTC has become much more aggressive in enforcing the antitrust statutes. And the FTC has gotten a lot better at winning those challenges. The FTC's got a pretty good winning streak going for itself over the last 10 years, where it has successfully blocked mergers that it deems anti-competitive. And in fact, recently, this last fall, one of the chairs of the FTC indicated that they may be considering retrospective actions against mergers that had already closed. And so you can see that the FTC is really ramping up and being more aggressive on these antitrust issues as it relates to healthcare. Next, the Department of Justice is also looking at these issues. There is a potential for criminal actions by the DOJ, but that's very rare, happily, in the healthcare arena. The state attorneys general are also involved and typically will work hand in hand with the federal agencies. A very high-profile case recently took place up in Idaho. The Idaho State Attorney General Office worked hand in hand with the Federal Trade Commission on that case and made identical arguments and work together throughout that process. And then lastly, competitors. The goal of antitrust enforcement is to preserve competition, and so competitors are frequently on the lookout for antitrust violations or antitrust concerns when there are potential mergers or acquisitions. So with that then, what are the agency's goals? First, the goal is, as I said, to improve consumer welfare by protecting competition. This doesn't mean that the agencies are concerned about protecting a particular competitor. Rather, they want to ensure that competition generally is protected. And the rationale for that is the notion that competition will give us lower prices, it will give us a better quality product or service, and more of the product or service that we want. And this is a little tricky in the healthcare industry because you don't have a case where, like you would go to a store and buy a product and the only parties involved are the retailer selling it to you and the customer buying it. In healthcare, that's different because we do have insurance, and that plays a significant part in how the industry works. And when you look at what patients, the consumers, want out of this, they want a Cadillac version of care. And that's especially something that they're willing to push for when somebody else, as they see it, is paying for the care that they're receiving. I'll note that the focus on lower prices as a benefit to competition has been frustrating to hospitals recently. And that stems from a perceived failure by hospitals to recognize the other benefits of competition, and specifically better quality and more output of what consumers want. And this came up pretty recently. The FTC and DOJ had a workshop in March where they had a number of panelists address antitrust issues in the healthcare arena. Shortly after that workshop, the American Hospital Association and some other groups sent a letter to the FTC and DOJ expressing their extreme disappointment in the workshop, and particularly felt that the workshop was imbalanced and did not address and had open hostility toward hospitals, indicating that hospitals only cared about increasing leverage against health insurers, increasing medical payments, while overlooking some of the other benefits that are provided, what those organizations called indisputable benefits provided by collaboration, by consolidation, such as rescuing failing hospitals, improving the quality of services at hospitals with lack of funds or lack of patients to justify improvements to equipment. And so there's some tension here as we look at the goal of increasing competition depending on what your viewpoint is. So what are the agencies looking at? And we're focusing really on the agencies, the FTC and DOJ. They are the driving forces behind most of the antitrust enforcement issues that we see. First, the Sherman Act. And the Sherman Act very broadly prohibits combinations that restrain trade. So if parties enter into an agreement and that is going to have a negative impact on trade, that is going to be a concern under the Sherman Act. There are a couple different categories of transactions. First are transactions that are per se or automatically unlawful, and those are price-fixing agreements and agreements not to compete. And typically, a case like that would generally look like, say, two physicians agreeing that they are going to each charge a certain amount for patients to receive a particular service. And if you have that agreement by itself, it's a horizontal agreement because it's between competitors, two competing physicians. It's a naked agreement. There's nothing else to it other than an agreement to fix price. That is per se unlawful. Agreements not to compete fall in the same boat. You can't say, for instance, well, let's agree that you will treat all the patients that live south of Salt Lake and I'll treat the patients that live north of Salt Lake. That those agreements without more would be naked horizontal agreements to restrain trade and would be deemed unlawful per se. Now, there are a lot of other agreements that impact trade that don't fall into those categories. And so where the parties, for instance, lack market power or the agreement includes significant pro-competitive benefits, then those types of transactions are analyzed under what the agencies or what the courts call the rule of reason. So when you look at a transaction under the rule of reason, does that mean then that it's automatically allowed? And the answer is no. This is where agencies will look at these particular circumstances of a particular transaction. And the critical consideration here is typically market share. How much of the market is going to be impacted by the parties to this particular merger, or acquisition. And this analysis is critical. It's fundamental to considering antitrust risk. And the big issue is, how do you define the market? And this is, as we'll discuss a little later, this is how the FTC has really gotten on its winning streak in challenging healthcare mergers, is that the FTC has gotten much better about defining the market in a way that allows it to show that a particular merger could impact negatively competition. So the market is the critical consideration typically. Agencies also consider the value added by the transaction. A lot of times this comes from efficiencies. If you're able through a transaction to make the provision of health care more efficient and save costs, save time, those types of benefits are going to be considered by the agencies and by whatever court or administrative body is considering a challenge to the transaction. What else? The Clayton Act. The Clayton Act prohibits acquiring stock or assets that may tend to substantially lessen competition in a particular line of commerce. And the agencies have a lot of latitude here. And as you can see from the slide, there's not a time limit. The challenge can come after the transaction. So you can, the agencies can realistically go in and try to unscramble the eggs, try to undo a merger that has been done. And again, and we'll talk about the St. Luke's case in some more detail later on, but that's an example where the FTC challenged a transaction and the court said, you're right, and we are going to undo that transaction through divestiture of the physician group that was acquired by that, and we're just going to undo it. and the Ninth Circuit agreed and recently upheld that ruling. Employment, though, is not an acquisition under the Clayton Act, so keep that in mind, that employment is different from an acquisition. And let's go back to the Sherman Act for a bit more of what that prohibits. It prohibits monopolization and attempts at monopolization. The courts have taken a conservative view of this. You can be a monopolist through good, solid American competition. That's fine. What courts prohibit is predatory or unreasonably exclusionary efforts to monopolize a particular market. Now, the FTC thinks that the courts are too lax in enforcing this, and the FTC also has the authority to bring actions under the FTC Act, which the U.S. Supreme Court has said parallels the Sherman Act. That said, the FTC takes the position that there are some circumstances where the FTC Act allows it to proceed that doesn't fit neatly into the Sherman Act. And so there's at least the potential that the FTC will use the FTC Act to reach beyond competition that would be barred by the Sherman Act. So with that backdrop, what are the types of behavior that really create antitrust risk? First, refusals to deal. That's a narrow behavior, as it says, it's actionable, where a party will stop a profitable relationship simply to force a competitor out of the market. That is going to raise an antitrust red flag. Tying and bundling of services together or products together also creates risk. And with bundling, the key, as it says there, is whether the product or service is sold below cost. And so if you are selling two products and you bundle those together and you're selling one of those below cost in a way that's going to impact negatively your competitors, that raises an antitrust risk. And then exclusive dealing or refusal to deal also raises an antitrust risk. All right, so those are some of the basic antitrust principles. Let's talk specifically now about healthcare. What transactions are the agencies scrutinizing? There are quite a few industries where the agencies have said we are going to focus on these, and right at the top of the list, as you can see there, is healthcare. It's a big target for the agencies. And why? Healthcare is not especially competitive. As I mentioned earlier, you have a consumer, a patient who wants the Cadillac version of care, and not any lower tier of care. And because of insurance, this impacts the way the market works. And another thing that impacts that is asymmetrical information. In other words, one side to the transaction, the provider has more or better information than the other side, the consumer. This is a market where often the patient only knows the cost after the service has been provided. And because of those differences, the agencies are very focused on making sure that the antitrust laws are being enforced in this particular industry. It also aligns with two goals, twin goals of the current administration, which are healthcare reform and antitrust enforcement generally. And those two combine to add an additional focus on the healthcare industry. As a result, We've seen much more vigorous antitrust enforcement under the administration. This shows no signs of letting up anytime soon. The chair of the FTC recently said it's one of the agency's highest priorities, and that really has shown in the attitude of the FTC in challenging mergers and in antitrust enforcement in this industry. What's happening in the industry now? With the Affordable Care Act, we are seeing quite a few changes. That is an understatement. And healthcare providers are looking to consolidate or to collaborate. When you look at the reasons for this, again, the FTC is looking at this as hospitals are working, for instance, to level a playing field with dominant insurers, to take advantage of the financial benefits offered by the Affordable Care Act to providers who collaborate to reduce Medicare expenditures. There are additional advantages, though, that I think, as the hospital groups rightly point out, that through consolidation or collaboration, the industry is saving failing hospitals. It's increasing the quality of care, and so there's a lot of movement and a lot of different reasons to support these consolidations or collaborations in the healthcare industry. Because of the focus on this industry, the agencies are trying to provide guidance to members of the industry so that they have a better sense of what the agencies are concerned about, what the agencies will and won't support. And so about 3 years ago, we saw the issuance of a statement of antitrust enforcement policy regarding accountable care organizations, ACOs, participating in the Medicare Share Savings Program. And that policy gave us some guidance about ACOs and how that would work, particularly to save Medicare costs and share in those savings. And this has been a key statement because not only has it been applied in the Medicare setting, but the same factors that we'll be talking about that the agencies consider, they've applied that more broadly and not just limited that to analysis of transactions regarding Medicare Share Savings Program. So what does the policy statement do? It provides financial incentives to ACOs. And so the upside is that it lowers healthcare costs. The downside, it does raise the specter of antitrust issues and review by the agencies. And so in a recent speech, this was about just over a year ago, the FTC Commissioner Julie Brill rejected the perceived tension between the ACO program and antitrust enforcement, and she said the goals of the ACA and antitrust enforcement are aligned and compatible. I do think it's probably worth pushing back on that a little and asking, is that really right? The focus on collaboration under the ACA is it seems frequently in tension with the goal of promoting competition under the antitrust statutes, and so it's at least worth considering whether that is always the case. One thing that the policy statement does is provides a safe harbor and allows parties to a transaction to consider whether their particular transaction falls within a safe harbor, meaning that if it does, the agencies will deem that it does not present an antitrust risk. And so there are three factors that the agencies consider, and then there's also a catch-all that the the transaction does not have any extraordinary circumstances involved. And so that does give the agencies a little leeway in the event they have questions about a transaction that would otherwise fall within that safe harbor. So let's look at the factors that the agencies consider. The first is that the ACO participants together do not provide more than 30% of a relevant service in any single ACO provider's primary service area. There are exceptions on this factor for rural providers, and the trick is that it is difficult to measure this factor. And as you see on the slide, St. Luke's gave us a good example of this. In the St. Luke's case, there was a lot of argument about what the relevant geographic market was. The St. Luke's, who was the acquiring party in this transaction, had argued that it encompassed the entire Treasure Valley, and for those of you outside of Idaho, that goes from Boise to Nampa, which is Nampa was where this physician group was that was acquired. But it encompassed that entire valley, Boise, Nampa, and beyond. And the FTC said, no, we think the geographic market should just be Nampa. That's all it should be. And there was a much smaller market, and as a result, the market share was much, much bigger for St. Luke's and the acquired group in that geographic market. The trial court agreed with the FTC and had a much smaller market than St. Luke's had argued for. The result was that St. Luke's and the acquired physician group had a very, very big market share, and that was a key factor in the court's consideration, both at the trial and the appellate level, in finding that the FTC's challenge was well taken. So let's look at the second factor then. No exclusivity. Exclusive dealing, as we saw generally earlier on, raises red flags with the agencies that we are limiting services or products that need to be provided. So the second factor is to consider whether there is no hospital or ambulatory surgery center participating in the ACO is exclusive to the ACO by contract, so your contract doesn't require exclusive dealing, or in practice. And it's the in practice that, that's where education is key, so that as a practical matter, there is not exclusive dealing that is going to trip up a potential deal under that factor. And then the third factor also addresses exclusivity and how that should not be a part of the transaction. So if the ACO includes a dominant provider, and this is a provider with more than 50% of the market share, then the dominant provider does not have an exclusive relationship with the ACO, and the ACO doesn't restrict the payer's ability to contract with other networks. And so there are a couple safeguards there that are built in. Outside the safe harbor then, we are again looking at particular factors for a particular transaction for the agencies to determine whether they have found what they call suspect behavior. And that includes anti-steering and anti-tiering requirements, and these are ways that you can steer consumers or patients to a certain provider, a certain service. Tying ACO services to services from providers outside the ACO, exclusive contracts, restrictions on information, price sharing, those sort of behaviors raise red flags for the agencies, and if they see those in a transaction that falls outside the safe harbor, that is going to draw scrutiny from the agencies. One really helpful point in the policy statement is that providers can get an expedited review of a proposed ACO formation if they're not yet participating in the Medicare Share Savings Program. And so that's, I believe, 90 days expedited review, which allows them to see whether the agencies anticipate that they're going to challenge the transaction, and that provides a good level of comfort as you're going into a transaction like that. So let's look at a real-life example of how this plays out. And the FTC issued an advisory opinion just about 2 years ago regarding a Norman, Oklahoma physician hospital organization, or PHO. And I think this gives us some good insight into the agency's views of healthcare collaboration. In Norman, the PHO included the Norman Regional Hospital as well as 240 about physicians. It had been operating for quite some time, about 20 years, using a messenger model, and that messenger model means that there was no agreement between the competitors that were part of that PHO. The PHO did want to move to a clinically integrated model and presented this to the FTC. The FTC analyzed this transaction under the rule of reason that we talked about a little earlier. So they avoided the per se analysis, and they did that in this way. There were agreements on pricing and price levels for patients. Even though those are per se illegal, joint price negotiations by competing healthcare providers can be evaluated under the rule of reason. If the partners are financially or clinically integrated and the agreement is reasonably necessary to accomplish pro-competitive benefits of the integration. And this is key, because if you don't have that financial or clinical integration and you have competing healthcare buyers that are engaging in these joint price negotiations, that would be a per se violation of the antitrust statutes, and that is going to cause a lot of problems. But in this case, because there was a desire to move to that clinically integrated model, the FTC considered it under the rule of reason. And again, that messenger model it also benefited the PHO because there was no agreement between the competitors. How do you achieve that financial and clinical integration? The financial integration, you share a significant risk of financial performance. Clinical integration, the providers share the risk of clinical performance. Nobody knows right now how much that really is, how much risk is enough, other than the notion that under the financial integration it is significant. So what was the Norman PHO doing to achieve its clinical integration? And the FTC noted a fair number of points that the PHO was using to achieve that clinical integration, put in place procedures to oversee and control costs while at the same time maintaining the quality of care, use an electronic platform to monitor physician compliance, participating practitioner agreement committing each physician to implement the clinical practice guidelines, and investing time and money to realize efficiencies. The capital investment on this was very minimal, but it was a point that the FTC considered. The need for joint contracting, what the FTC found and what the PHO presented was that a consistent panel of like-minded physicians with shared commitment to participating in all aspects of the clinical integration program for all patients under network contracts was needed. Otherwise, they were concerned that physician panels might vary from contract to contract, and they incentivized the providers to participate in the clinical integration projects. So with that then, what the FTC did is it determined first it wouldn't impact the number of contracting alternatives. And here the FTC noted that the agreement was non-exclusive, and so it was probable in the FTC's view that this would not impact contracting alternatives. The FTC was concerned that there were a substantial portion of the physicians in the area in the network, and I think this was, if I remember right, between about 70 and 80% of the physicians in the area. And the PHO worked with the FTC to assuage these concerns and pointed at a number of mitigating factors. First, that the representations that customers could bypass the PHO and contract directly with providers. Take that for what you will, but that was a point that they raised and the FTC accepted. The network would not force payers to contract with the PHO. This was a key point. And that the network would not use its monopoly power to limit competition in other areas. And so it was only the hospital in the area, but it would agree, for instance, not to require patients to use PHO physicians. And the Northern PHO did a good job, I think, of showing the FTC that it would offer counseling to physicians and guidance to providers to avoid spillover where, notwithstanding the non-exclusive terms of the agreement, you would have a situation where, as a practical matter, this was being run as a monopoly, and there was exclusive dealing as a practical matter. And so against that backdrop, the FTC said, yeah, that's enough, and we'll allow it to go ahead. And I think it's interesting to consider the FTC was very focused on the non-exclusivity of this deal, but what if all of the area physicians had been included? Would that have impacted the non-exclusivity analysis? Maybe it would, maybe it wouldn't. We just don't know. So what are the takeaways from this? First, it's interesting how early in the process the FTC was willing to enter its advisory opinion. This was done before many of the final points of this proposed PHO transaction were going to take place. It's not clear if all of these steps, too, were necessary for approval. Was everything that the FTC set out necessary for the PHO to show that the transaction was appropriate? The FTC did leave open the door, and as I mentioned earlier, we've gotten some feedback very recently from the FTC that they are perfectly willing and considering looking back at mergers that have already closed and reaching back to see whether those are in fact anti-competitive. And so here we see that same mentality, that if there are serious concerns that arise out of the PHO, the FTC would reserve the right to go back and analyze that again. This is a program that was not linked to a Medicare shared savings program, but again, the policy statement was very helpful as a guide in considering what the FTC considered as part of this process. And again, I think a big takeaway from this, too, is that the fact that there is clinical or financial integration does not make a transaction bulletproof. there are still antitrust risks, and sometimes significant risks, that need to be addressed. That said, though, how do we minimize the risk in a transaction like that? Again, non-exclusivity, that is critical, a critical part of that analysis, and it lowers the risk of antitrust enforcement action by the agencies. And do not prohibit carve-outs of services. That's another one where if those carve-outs are allowed, that lowers the risk in the agency's eyes. Vertical acquisitions. This is something that has not been historically a key aspect of antitrust enforcement in the healthcare industry. And in fact, there is very little healthcare analysis in this arena. And that's, I think, because generally they don't have the same sort of risk that horizontal acquisitions do. Or in other words, acquisitions among competitors have much more risk than acquisitions among providers at different levels who do not compete directly with each other. And again, competition is key here. Typically, physicians will compete with each other, but do not compete with a hospital. And so oftentimes there's less of a risk in a vertical transaction. And in fact, economists generally tend to favor vertical acquisitions. They see that they produce efficiencies and that can lower costs that can be passed on to consumers, and that's beneficial for competition generally. If there are multiple acquisitions, though, that does tend to raise concerns that you are consolidating the market in an anti-competitive way. So with that, then, let's look at the St. Luke's case, and this is, probably this is a really good hot issue in the healthcare mergers and acquisition field as far as antitrust enforcement goes. So St. Luke's acquired Salzer, which was an independent physician group. The group was in Nampa, as I mentioned earlier. St. Luke's also had a physician group at the time in Nampa, and there was another hospital, St. Alphonsus, that also had a physician group in Nampa. The FTC said that the acquisition included the right to negotiate health plan contracts, to establish rates, charges. St. Alphonsus said that it would give St. Luke's a dominant market share and allow St. Luke's to block referrals to St. Alphonsus. And so the challenges to the transaction were both vertical challenges and horizontal challenges. The FTC worked hand in hand with the Idaho Attorney General's office and throughout this process. All right. The trial court found that the transaction threatened competition and ordered the divestiture of the physicians group by St. Luke's. Notably, this is the first case that the FTC's litigated through trial challenging a physician acquisition. And very recently, the Ninth Circuit affirmed the ruling of the trial court. The court found that the relevant geographic market, as found by the trial court, was correct. In other words, it considered the Nampa geographic market and not the entire Treasure Valley. And it was interesting because the court noted that a third of Nampa residents would actually leave Nampa for primary care, but it still said that the market should be confined to Nampa because many people obtaining health care elsewhere did so because they worked elsewhere. So it was kind of that St. Luke's thought it could show the broader market based on where people who lived in Nampa were actually receiving primary care, and that was shot down by the trial court and the Court of Appeals. In addition to the market, let me step back. Once that market was defined so narrowly, though, the court found that the merged system would give that would hold about 80% of the NAMPA primary care market. And if you remember earlier when we were talking about the safe harbor provision of the policy statement, that safe harbor applies under 30%. And so this, as the Ninth Circuit put it, blew through those guidelines in, as the court put it, spectacular fashion. It's a little tricky in a case like this, though, because the market itself, the market participants are so few. Salzer, the group that was acquired, had 16 adult primary care physicians. St. Luke's had 8, and St. Alphonsus had 9. So there were very few actual participants in the market providing health care services there. But nevertheless, the court found that was the appropriate market to consider as part of its analysis. The Ninth Circuit also upheld divestiture as the preferred remedy. And what St. Luke's had argued is that conduct remedies were appropriate. In other words, that the court should take more of a wait-and-see approach and show and oversee the conduct of the merged system in a way that would prevent the risks associated with the transaction. In other words, it would prevent increased costs as a result of the transaction, for instance. The Ninth Circuit rejected that argument and said that divestiture is preferred. It is simple to administer, and it's the preferred remedy. All you need to do is divest it, and then you're done. It doesn't require ongoing oversight by a court or even by the agencies. And because of that, that's the simplicity in that approach. It is the preferred remedy, notwithstanding the fact that that the court essentially ordered these parties to unscramble the eggs. They had already gone through with this merger. This was one that was below the threshold for agency approval under the Hart-Scott-Rodino Act, so that hadn't been filed. And this merger had been done when it was challenged, and the Ninth Circuit came in and said, we're undoing it, after the trial court said the same thing. It's interesting, too, to consider what the parties in the action were focused on. St. Alphonsus was concerned that it would foreclose competition, and particularly concerned that the merged system would have no incentive to refer patients outside the acquiring group, St. Luke's. The FTC, though, did not really focus on that, and instead argued that this gave St. Luke's the ability to get higher rates from commercial payers. And so you see a different focus that the FTC has, and again, this I think takes us back to the concerns that the hospital groups have raised in working with the agencies, that the hospital groups feel that the other benefits of consolidation or collaboration are sometimes being wrongfully ignored by the agency. Certainly in this case, though, the FTC's primary concern was the ability to get higher rates that would result from this transaction. And I think that's the key takeaway from this case, is that the FTC worries about costs. And hospital groups don't like that focus, to the extent that focus eliminates the concern for other benefits of the transaction. The FTC is concerned about reduced competition in the hospital services market, and that's, I think, central to the analysis. And again, the market is critical in determining antitrust risk. If the court had adopted the market analysis that St. Luke's was proffering, this probably does not cause a lot of concern for a court. But the court didn't do that. It adopted a narrower view of what the market was, and that's something the FTC has gotten much better at showing over the last 10 years. And as a result, the FTC was able to be successful in this lawsuit. Generally, I think there are a couple of questions that the FTC asks in considering antitrust risk. And the first is, are the claimed benefits of the transaction viable? And are they merger specific? Is there another way that we can do this? So those are the two questions to consider when to understand that the agencies are going to be considering when you're contemplating a healthcare transaction. Can you show that the benefits from the transaction that you think will occur are really viable? If they are, what evidence do you have and how can you present that? And then second, is there another way that those benefits can be obtained apart from, say, merging? So that is the presentation. A few conclusions that we can draw, I think, are first, antitrust analysis doesn't lend itself to bright lines a lot. There are a lot of fuzzy issues. There are a lot of factors that are taken into account by agencies and by competitors. The factors aren't necessarily all required to be considered. And it really is weighed in a balance other than transactions that are per se unlawful. Beyond that, the rule of reason requires balancing different factors, and there's just not a good way to draw bright lines in that. Second, the agencies want to protect and encourage competition. The agencies are, in my experience, have been very good to work with. They want to be as clear as possible for parties to understand the potential concerns that they have, and so that's helpful in a pre-litigation context. After that, it's a little different, but they are very good to work with pre-litigation. And finally, there's really not much sign that this is going to change anytime soon. Healthcare is a highly, highly regulated industry. If you looked at healthcare in the United States as a world economy on its own, it would be the 5th largest economy in the world. This is a huge area, and we can expect that oversight, and particularly oversight in the antitrust arena, will continue. Thank you very much for participating on this today. If you do have any questions, feel free to send me an email or call or use the chat function on this webinar. I'm happy to respond to any questions that you have. And it doesn't look like we have any now, so please send those if you do have them, and we'll follow up later. Thank you again for your participation, and goodbye.